So, hey, all, I am Justin, and this is Kentucky School Law. On this one, we're diving into private schools, just a smidge. We're not going to go super, super deep. Private schools both sort of exist outside of most school law as a more private sort of corporation space, and it's a little bit less Kentucky, more federal kinds of things. So, we're just going to give it a little taste so you have some sense of it for your own careers. Okay, so let's dive in. In this case, in the 1920s, sort of serves as a foundation, won't spend a ton of time. Pierce versus Society of Sisters, Oregon passes a law that says only kids that are going to from 8 to 16 must go to public school, essentially trying to push back against parochial schools and Catholic schools in particular, which was the fashion at that time in the United States. And Kentucky did things as well, like adopting a Blaine Amendment here in Kentucky, which is very hotly debated in today's world as we talk about public money for private schools. So in this case, the Supreme Court ruled that it is unconstitutional for a state, Oregon in this case, to force all children to learn only from public school teachers, as in private schools can exist. Okay, so that gives us a sort of foundation there. Since that time, of course, private schools have been a consistent part of our society. Across the nation, you can see in that chart, sort of they continue to represent about 4.7 million kids, about 30,000 schools. It is decreasing a bit, the number of schools, but sort of small, very tiny places going away, and the big schools getting a bit bigger. So enrollment's consistent, just the number of schools seem to be going down. Um, there is St. Mary's High School in Portland, Oregon. That school is operated today by the Society of Sisters, right? So this is not all historic stuff. That case still very much alive today, a century later, because that religious organization continues to operate that high school, all girls high school in Portland. Across the nation, what's this look like? So you can see for us in Kentucky, we are right in the middle. 9% is sort of the national average. And there we are right at 9% across the country. You can see what that looks like, a little bit less private education out west and in the south, and a little bit more private education in the Northeast and Midwest. Makes some sense historically, as a lot of that private education got going earlier in the nation's history, and so the places that were developed earlier have more of a presence. Now, also, a little bit later in the 1940s, there are going to be some limits on private education. This particular one case is still hot today, right? This is the root of what we're debating a lot about today with public money to private schools. Here, the Supreme Court was asked to make a decision in a case about busing, of using public money to pay for buses to private schools. Of course, private schools wanted to have buses to their school. Why would they not? But here you can see the Supreme Court pushing back a little bit and saying, no, there are some limits. We're not going to move the public money to private schools. Very, very hot today, but you can sort of just get a sense of there's limits about what we're going to allow public money to do. So what's this mean if you're in the world of private schools and school law? Let me give you like a real high level overview, just so you get a sense of it. I get this question a lot, and it's an everywhere kind of question. There's Frankfurt Christian Academy right there in Frankfurt, and it's a sort of everywhere kind of question. So are you behaving as a non-state actor or as a state actor is the first sort of fundamental question. Seems easy. If you're a private school, it's a non-state actor. Well, the deeper question is, where did the money come from? If you're running a federal program around student lunch or after school, you are probably behaving as a state actor, and state school law, federal school law, might apply to you in those instances. So it's always a good first question to just verify in your own minds there's not public money at play. If there is public money at play, then probably broader school law might kick in. But if there is not public money at play, then you're a non-state actor and you get a lot more freedom. Now, if you're a religious school of any kind, the ministerial exception might kick in. So Lutheran schools, Islamic schools, Catholic schools, where the employee might be treated more like a minister, depending on what they do. So we see cases around this quite a bit, around personnel issues in private school. And it's also like a really good first question to ask yourself as a private school leader in this instance. For the people that were involved in anything going on in our school, was it their responsibility to educate people in their faith? If at issue in a particular issue related to private education is sort of the delivery of the faith, the ministerial exception might apply, where the free exercise clause is really kicking in here and giving the religiously affiliated school quite a bit of sort of religious freedom to dictate how they want to do employment or how they want to teach a certain subject. So there is sort of this root of the question frequently that's worth asking yourself: are we currently conveying the faith here at the school, or is this just running school? Right? The lunch program is probably not about your faith. It's just doing the lunch program. And so you're not going to get as much freedom around that question as you are around how to do religious instruction, for instance. Next up is governance and law, and like who's in charge, which is a fundamental question. So, for instance, with Catholic schools, I left that first one up there of canon law. And this applies if you're at a Baptist institution, Lutheran, Islamic, whatever. Is there an overarching religious body that is sort of the dominant body that you have to report to by operating within a religious context? If not, then you're going to be operating more in the civil law kind of world, like a nonprofit board, right? So if you are at a non-sectarian private school, then you have like more of a traditional board that you're reporting to. Private religious schools probably also have a board, but they might also have a pastor or a priest or something like that, rabbi, who is ultimately the final judge based off of the religious law that might be applying in that particular instance. So in charge of, if you're the principal at a private school, you're dealing with multiple layers of governance, all of which sort of have their own legal requirements. And you're having to sort through and balance and figure out which governance model is sort of applying at this moment. Hard. Canon law, civil law, local law. There's a lot of different layers that you're trying to sort through. But at the root of all things private education are contracts. This is so massive. And if you find yourself in the world of leading a private school, I encourage you to get some coaching on contract law, because this is so much of its employment. The student families are paying you through a contract kind of model. You got vendors doing contracts. You might, if you're leasing space, that's going to be through a contract. There's going to be athletic contracts at play. There's a lot of contracts. You're managing most of your school day and operation through contracts. If you're a small private school, you're not going to get a lot of help on that. So this is where, as a private school leader, you just need to have some expertise. Next one up is around student protections, where you're still having to deal with a lot of law that applies to kids. Abuse and harassment, some due process, discrimination, like you cannot discriminate on the basis of race in admissions. We have had cases about that. Disability law might also apply. The ADA might apply, even if IDEA does not apply. Student records, student privacy, student injuries, and torts. So while you get a lot of freedom on a lot of fronts, the protection of the kid in society, all of those laws about the protection of the kid still apply. And you're sorting through those kinds of protections that are applying to kids, right? So, if you're adopting a discipline policy that is based around corporal punishment, you got to worry about torts. You need to worry about abuse and harassment, right? Those kinds of laws still apply. All right. Also, managing money is a huge part of what you have to do in private schools. So much because there's more money coming in more directly. You have control over more. A principal in a public school's budget's usually quite small, but in a private school, you're dealing with quite a bit of money. So a lot to manage there. And finally, a lot of technical laws that apply in this space. So that's just a quick, I ran out of time on private school law. You can pause the video, look at those technical laws. All those apply. Thanks for watching.